Hi, I'm Anna Denton-Jones, and in this fourth Knowledge November video, I'm discussing the key ingredients to a fair dismissal. So you'll be aware that in order for there to be a fair dismissal, a tribunal is going to need to see two things. Firstly, that there is a substantively fair reason, so capability is the way in which performance is labelled for the purposes of the legislation. And secondly, that the employer can get over the hurdle of having followed a fair process around a dismissal for that reason. So this video is going to focus on what does that fair process look like. So you're likely to go around the houses a number of times in terms of the process for managing performance. There would be an expectation of an invitation to a meeting to discuss the issues formally. So just like an invitation to a disciplinary meeting, that invitation will be giving the person enough advanced warning, if you like, as to what they're facing in the meeting. So that would be writing to them, telling them that there are some concerns around their performance, giving them a flavour of what those concerns might be, so they've got sufficient information, this is now me quoting directly from the ACAS code, that they know enough about the concerns that they can come to that meeting prepared to answer a case, and are aware also that it might lead to a disciplinary warning or even dismissal if we've reached that stage. Now, how long in advance of the meeting is going to depend on what you've said in your policies. But as a minimum, you're going to be talking 24 hours. So somebody comes into that meeting knowing what they're facing. We then need to have the meeting to discuss performance. And I talked last week about the need to give some concrete examples, observations, feedback about what is going well, and also the things that need to improve and why they need to improve. It's not good enough to just be criticising somebody and saying, you've got a bad attitude. We need to be giving examples of how we've seen that manifest. So it might be the way in which you dealt with that particular customer on Monday last week. Is of concern. We would have preferred it if you dealt with it like this. That kind of conversation. In terms of what needs to happen going forward, we need to set a timescale for improvement. Now that's going to very much depend on what the criticisms are. So there are some things that can be corrected straight away. So if the criticism was the way in which somebody spoke to somebody, you can be saying, I expect you, the next time one of these conversations happens, for it to be dealt with in this way. So that might be something immediate. There might be other things that are more sort of weekly tasked, or putting together a feasibility study on merging two teams together might be something that you give somebody a month to do. So you need to be led by the content as to what the timetable looks like. And it doesn't have to be identical timescales for each of those things. So some things might happen on a daily, weekly, monthly, even, over a few months basis. You then need to review progress. So that's diarising review meetings and sitting down with a person and looking at whether there's been an improvement, whether there's been a partial improvement, or whether, sadly, we're still not seeing the turnaround that we want. And if we're not seeing the turnaround that we want, it may well be that we then formalise or ratchet up to the next level. So that might be starting with a first written warning, moving up to a final written warning, and potentially dismissal if previous warnings haven't worked. And you would be expected to move up that sort of staircase, if you like, towards a dismissal. And that's where it can start to feel like Groundhog Day, where you're having the same conversation. There's that element of repetition, but that's really useful because if we're documenting in some kind of performance improvement plan what we're expecting and we're still not seeing it, then that's all good evidence for an employment tribunal of a fair process being followed. I mentioned that ultimately we might end up in dismissal territory. That's where we've moved our way up through these stages. But before we get to that point, you would be expected to consider whether there is an alternative. So that might mean demotion into a lower role. It might be moving into something else that you have available. But we'd be expected to consider if dismissal, if you like, the last resort was the answer, or whether actually there was something else that we could be doing. So if there is alternative employment, again, important for us to be documenting the fact that we've made that offer and perhaps it's been turned down. Where we do end up dismissing, then we're going to have to do that on notice so that we don't breach the contract of employment and gift somebody a wrongful dismissal claim. So employers may well make a decision to pay in lieu of the person working out that notice period. The final ingredient is going to be the appeal stage. Just like your disciplinary situation, your appeal is an opportunity, if there have been any shortcomings in the process that's been followed to date, to correct something. And I'd recommend an appeal stage, even with something like bringing the employment of a probationer to an end, just because it's that chance to flush out if there is some argument, I don't know, about a disability or whistleblowing or any of the things that employees sometimes raise. It gives us the opportunity for somebody more senior who's not been involved at an earlier stage to look afresh at what's happened and consider, is the organisation being reasonable in what it's doing here? And, you know, many times they're going to say that the answer to that is yes. But if there is something, I don't know, disability, I remember an Asperger's case many years ago where a probationer had just not raised the reason why they may have had different ways of thinking and doing something and were struggling. They hadn't told anybody what their needs were. Obviously, at the point that it is fleshed out, we're into reasonable adjustment territory. We're into giving it another whirl whilst we see if those issues can be addressed. So it may be that a pause needs to be placed on the process as far as it's got, whilst we get some medical advice, whilst we explore that issue. But I always view appeals as an opportunity. Can feel a bit of a drag once you've already been through this long process, but I always encourage you to see it as an opportunity, because that's the way I look at it as a lawyer.